Good morning. Are you Ridley McKinney?
Yes, ma'am.
Or McKinley, I'm sorry. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor. And I think we just go on counts 2 and 3 on this.
We do, Judge. We're not going to go full. We're going to draw allegations.
Okay, state's going to abandon 1. Will he waive the formal reading of that motion?
He will,
I
Your
just
Honor.
asked you that, I'm sorry. Mr. McKinley, in cause number 19-33345, I have a motion to revoke your community supervision. Shows that you were placed on probation August 1st of 2022 for the offense of aggravated assault family violence, and that was a 5-year term in prison that was probated for 8 years. Is that correct?
Yes, ma'am.
It alleges in count 2 that you were at a location other than, that you violated your probation because you were at a location other than your residence at approximately 10:24 p.m. April 9th of 2025. And is that true or not true?
It's true.
And then count 3 alleges that you are behind in your court assessed fees. Is that true or not true? And what is the status of that offense from count 1?
I believe it's been refused.
Judge, it was refused by our office.
Okay.
And the laying witness is the same as this one, but therefore we refused. We're not going to go forward with the allegation.
Okay. Is there a no contact order in the probation
No,
though?
they're married. You know.
They're married, Judge, and
With
it's,
children.
I know the optics of it looks bad for the kind of offenses that he's on probation for.
Y'all hold it down just a little bit. Go speak.
So it looks bad for the kind of case that he's on probation for, but the complaining witness has come to my office. I've spoken with her. I think
We followed up with the judge. If we had it to move forward with.
Okay, I just wanted to check. All right. Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation and order 60-day jail sanction, and it looks like you've got 44 days credit. Is that your understanding?
Yes, ma'am.
State tenders number 1.
no objection.
It's admitted. Any evidence that Mr. McKinley is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order a 60-day jail sanction as a condition for that. These allegations, you will get credit for 44 days. Here's the thing, something's going on, okay? And even at this point, if I think something's going on, the proof that is required for me to revoke your probation is not the same as it's required if we go to a jury. And if there's anything that happens again, whatever's going on between you and her, if y'all are not good together, then don't be together because you're going to end up in prison. The offense that you're on probation for is obviously very serious. You've already agreed, when you got this probation, you already agreed to that 5-year sentence in prison. You violate your probation in any way again, you've got the 5 years. I don't care if it's having to do with her, if it's being out past curfew, if it's not showing up for appointment, this is it. So whatever's going on, y'all need to get whatever help you need. If it needs to be separated, then you need to be separated. Otherwise, you might end up in prison. So you have to figure out what's really best, to be in a volatile relationship in front of your children or to be in prison.
Yes, ma'am.
You understand?
I understand.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. As soon as you're released from jail, first thing you do, report back to probation, get going on everything like you're supposed to. All right, good luck to you. In cause numbers 19-33340 and 20-36095, on probation for theft of property and theft of service, and a motion to revoke has been filed in each of those cases. There's a new offense indicted 250297 with the allegation of theft of property. And so that theft new allegation is from offense date of August of 2023. And so the Obviously, that was some time ago. There's a motion, let me get to the right paperwork. In each of these cases, obviously alleging that new offense. Mr. Rojas has filed motion in each of those, motion to revoke probation cases that I set a bond, that currently they do not have a bond. Those are deferred, correct? Are they both deferred?
I think
Let me double check.
I think they're straight probations.
They're straight probations?
They
Okay. So Ms. Leonard isn't necessarily entitled to a bond as if it were a deferred, but we're here to talk about that. Mr. Coleman has filed a state's reply to that motion. I have read and reviewed that and obviously understand Mr. Coleman's position. Mr. Rojas, you may go forward.
Call Ms. Leonard, John.
Ms. Leonard, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay.
Okay, Ms. Leonard, how long have you been in jail now?
14 months.
And it's my understanding that you've got a newborn baby at home? How old is that child?
3 months.
All right, and there's a little, you're having, or before you come in, you were having issues with breastfeeding or with feeding the child?
Yes, ma'am.
Tell the judge about how it's.
My daughter's been breastfed since she was hospitalized at 3 weeks old. She also has a heart murmur. And since I've been in here, they've had trouble with her latching on to a bottle.
So let me ask, it looks like in these motions, the primary allegation obviously is that new offense. And then there is some community service hours and then very behind in fees and fines. Other than those things, I've got probation here. And if you'll just state your name for the record, ma'am.
Linda Cooler.
And is there, other than those items, is there any other issues that you are having with Ms. Leonard that I need to be aware of?
No, Your Honor.
Okay. If this new allegation was more recent, I'm not sure what happened with the timeline on this, and doesn't, for this purpose, I guess, doesn't really matter. But because it's been so long, and it looks like other than some fees and community service, everything else has been going well, I'm going to grant the motion to set bond in cause numbers 19-33340 and 20-36095. I'm going to set the bonds in each of those cases at $5,000 in each case. And obviously, if you make those bonds, the first thing you do is report to probation and do everything you're supposed to be doing while you're on probation. Yes, ma'am.
Is that included with the $10,000 bond with the new charge?
You have 3 different bonds. You've got a 10,000 and 2 5,000s. And so you need to get busy, because while this is pending, obviously would be, I would think, in your benefit to try to get some community service hours done, to get a job, start making some payments, show me and probation and the district attorney that you're trying, because just me setting bonds doesn't mean that you're out of trouble for this. You could still go to the state jail prison. So it's very important that you do everything that you're supposed to while you're on the probation, okay?
Yes, ma'am.
All right, we'll see y'all back at an announcement. All right, ma'am, are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Miss Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor. No, Your Honor.
I have something, Your Honor.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay.
It's not being tracked at this point.
Okay, thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right?
What do you want?
I mean, it says right here, she just wants to do her time so she can move on with her life and put the case behind her.
Is that accurate?
Yeah, but I mean, if I
like, get the chance to, like, get reinstated, I'll do it too.
Which do you prefer? What do you want?
If I can do the 60 days that they offer me and, be off
Well,
probation.
60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you today.
Yes,
So,
ma'am. Okay, so,
What-
I'd rather be reinstated.
okay,
It is a misdemeanor, you know,
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take guilt out on it. However, the defendant's version does indicate some mental health issues. And obviously, probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow the, maybe the recommendation you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an what do they call, antisocial personality disorder, whatever her issues are from the mental health standpoint.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously, I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything
She has
where she
no-
was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there with,
Okay,
obviously, things that can be dealt with in therapy.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't do. I'd ask that we revoke her.
so, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean, all right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Can I get my phone and my system?
Talk to the bailiff. Just talk to the bailiff. Yeah, come over here and get a thumbprint, please. For Linton Arsenault. And Mr. Arsenault is charged with failure to comply with sex offender registration requirements. We've gone over before with, I think that was maybe with Mr. Lewis before you were appointed, and what the offer was and rejection, and what's the status?
The state's not gonna go any lower, Judge. That's the only offer, and it's gone today. So he can take it today, or he can go to trial.
Okay, thank you, Mr. Hoffpower. Mr. LeBlanc?
And I've conveyed that to him, we've discussed it. And then my understanding is you can be more rejected or you can.
You want to go to trial? Okay, so I just want to make sure, and we've gone over this before, you understand if you go to trial and you're found guilty and those prior convictions are true, that you would be considered a habitual offender. Your minimum punishment would be 25 years, you understand? And it looks like that offer that was made is for going on count one only for a 10-year term in prison. Again, you've got every right to reject that and go to trial. Just want to make sure you understand possible consequences, options, and all of that. All right, then we'll get it set for trial, and Mr. LeBlanc will begin preparation for trial. Yeah, it's one of those names that are on my list that I'm tired of seeing. It's you too, I'm sure. Good morning. Are you Adrian Housley?
Yes, ma'am.
Mr. Housley was previously in court, entered pleas of guilty to, or plea of guilty in cause number 25, DCCR 0290 to theft of property with previous convictions. It's a state jail felony. And we pleaded as, no, and there were prior offenses, and so the agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections because of the criminal history before. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Any additions or corrections?
No.
All right, Mr. Walker, you may proceed.
Judge, what I thought was going to be a long argument for us, we're actually in agreement with the PSI report, and we're asking the court to follow the recommendations and place Mr. Housley on probation.
Mr. Hoffpower?
Judge, we understand in light of what the argument is and the facts of this particular case. However, the court will leave it to the court's discretion. You see his criminal history. He has been in the penitentiary numerous times. So I leave it to the court's discretion whether or not it wants to place this individual on probation or in light of his history.
The underlying, what he ended up pleading to, was it a third or a second?
Second.
Second.
2 to 20 because it's habitual.
That's what I wanted to make, okay.
Yes, sir.
Okay.
And Judge, if I may, what we're talking about is over a 4-month span with all the items added up, we're talking about an amount that barely gets over the threshold for a Class B misdemeanor. A 62-year-old Army veteran suffers from PTSD, and as the PSI report shows, he's a low-risk candidate for it. He's not a threat to it. He's went 15 years from his last offense without getting in trouble. He's showing that he's capable of fitting in with society as well as an interest to better himself. And that's why we're going to ask that you put him on probation.
Mr. Housley, on paper, you sure don't look like you deserve probation with your criminal history. Mr. Walker is correct, and the pre-sentence report writer has stated and shown me that it looks like you really are doing well in so many ways. With your history, it just kind of is beyond me, though, that you would go and do something really as minor as what you did, knowing with your history that it doesn't matter how minor it is. At some point, you got to stop, or you just keep staying in prison. Are you still working at Dragon Products?
Yes, ma'am.
You've been, I mean, it looks like you're following through. You following through with your, is it the veteran services in Spindletop as well?
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Housley. I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years.
Yes, ma'am.
And I'm going to order a $500 fine and order that you follow all of the rules and conditions of probation. That will include that you are on the specialized mental health caseload to help with any issues with regard to PTSD and the things that you're going through. You'll be required to follow all of their rules and conditions as well. There's kind of two sides to this, right? And so
Yes, ma'am.
deferred probation, a lot of times people see and wonder, well, why did they give them that opportunity at not having a conviction on your record when you have all the convictions? And that's for me. It's not for you. Because now that 10-year cap is gone. I didn't send you to prison. So if you do your probation right, then you won't have this conviction. And if you're successful at the end, the case is dismissed and you will be able to continue living your life like you have been, it looks like, for the last 16 years or so.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you're back in court, you're found guilty, which means you have the conviction, and I have the entire range of punishment, which is up to 20 years.
Yes, ma'am.
And on paper, that's what it looks like you will deserve at that point if you don't take advantage of this. So I hope you do. I'm going to hand you the trial court certification that shows this was an agreement I followed, so you waived any right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Yes, ma'am. Thank you. God
Yes,
bless.
sir. Thank you. You too, sir. Thank you, Mr. Walker.
Thank you. Next, excuse, Judge.
Yes, sir. Good morning. Are you Michael White? And Mr. White, you are on probation in cause number 23, DCCR 1117, for the third-degree felony offense of driving while intoxicated, third or more. And probation sent an administrative hearing. It looks like as part of your probation, you were ordered to enter and successfully complete the SafeP program, and that was in order to have a scram device. When you got out of SafeP, it looks like you obtained the scram on April 8th, and then they notified probation that you were not meeting your financial obligations, and they terminated that, and so you don't have the scram anymore. Is that correct? So, are you working? Why not? Where have you looked? What different places? Speak up, please.
Home Depot Road, it's a construction company.
Okay. Has he given you notification of all of that?
He has. He also gave me an award letter from Social Security.
Okay.
He received, I think, was it $400?
It's only 220.
220.
He's under review right now.
I can't hear you.
He's under review right now.
Okay. So that was just a partial disability.
Yes, ma'am.
Okay. Well, I guess an option is for him to come to the office more often to take alcohol tests there.
He is coming frequently. He's on the color code where he has to call every morning, and when they're calling his color, he comes in and does units. He also is in the outpatient portion of safety, and they rate him frequently there. So.
But are they also doing alcohol testing?
Yes.
Okay. And everything's going okay with the outpatient?
Yes, he hasn't had it.
The only issue is the scram.
Yes, he's going to group meetings and all that.
Do you drive? Okay. So here's what I'm going to do, Mr. White, based on your income and the partial disability. I'm going to retract that order that you have a scram device. I'm going to order that you continue with the drop program, follow all of those rules. Obviously, if you test positive for anything, including alcohol, you'll be right back in here. Also, as of now, a condition of your probation, since you cannot have the scram or can't afford it, is that you do not drive. So you cannot drive any vehicle at all ever without further permission of the court. So if you get to a point where you have the ability to get a car or drive, you're going to have to go through probation, request permission, and then I'll have to take a look at how you're doing and what I can do to make sure that I feel like everybody's safe. Does that make sense? Okay? Anything else you think? All right. All right, keep doing what you're doing. Thank you, sir. Let's see. Mr. Wilkinson, this is your initial appearance in cause number 25, DCCR 0260. You're charged with deadly conduct, discharging a firearm from September 13th of 2024. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, not just yet. I was going to ask if I could have a little bit more time in order to come up with more funds to hire an attorney.
So what I'll do is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans, Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice. Good morning. Are you Drayden Rose? And Mr. Rose, this is your initial appearance in cause number 25 DCCR 0789. You're charged with the third-degree felony offense of assault of a security officer from April 16th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I'm in court,
How old are you?
18.
Are you still in school?
I got my GED.
You got your GED? So, are you working?
I'm finding a job.
So you don't just get a court-appointed attorney. So what I'm going to do, since you made bond, I'm going to reset your case for about 30 days and do a couple things. One, you need to try to get a job first. If you get a job, bring me that information on where you're working, some kind of pay stub or just something that shows where you're working. I also want you to apply for at least 5 jobs a week. And if you don't have a job, you need to bring me where you've applied. So if you're print something out or copy something from where you've gone. And then in addition to all of that, I want you to start talking to attorneys, okay? You need to talk to at least 3. They all charge different amounts. They have different payment plans. I want you to start talking to them so that when you get a job, you can see maybe what you can afford or what you can't. If you do all that and you still can't afford an attorney, then we'll talk at the appropriate time about a court appointed. If you don't do those things that I asked you to do, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail for not following that court order. Do you understand all of that? All right, if you'll step in front of the clerk, she'll give you a reset notice. Good morning. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino, did you get someone hired?
I did not hire him yet. It's Cody Crenshaw.
Corey?
Well, Corey is. Cody
Uh-huh.
Crenshaw. He asked for $4,000 down.
Okay.
And as soon as I get that, which should be about 3 weeks from now.
Okay.
And I'll be able to get him hired for.
All right. You've been here a few times, so I'm going to reset you one more time. You need to get him or someone else hired before that next court date. Again, just bring that reset notice to him. He'll tell you what to do. If it's not going to work out with Mr. Crenshaw for some reason, then talk to at least 3 others. Bring me those names. All right? Step in front of the clerk. She'll give you a reset notice. Good morning. You're Presley Viltz. Did you get someone hired, Mr. Viltz? No? Who'd you talk to? Okay, did you write down the names? Well, no, I mean, I tell you the same thing I tell everybody. Bring me back the names of the people you talked to so that I know you've tried, and then we'll discuss your options. Same words I've said for 11 years to every single person in here, so no one can ever say that I didn't say them.
Yes, ma'am.
So what part of bring me back the names of who you've talked to did you not understand?
I understood. I just forgot.
You just forgot. Okay, so you're in felony court. You don't just forget. Because if you don't do what I asked you to, then I can put you in jail right now. I'm trying not to do that. I want you to follow the rules. It's not that hard. You have 30 days. Talk to 3 lawyers. Try to hire them. Did you talk to 3? You really talked to. So when you first answered, you said you talked to 2. So be careful what you're saying. All right? And you're probably nervous right now, and I get that, but be careful what you're saying because you're saying some different things. I'm going to reset your case for 2 weeks. You need to talk to 3 lawyers. You need to bring me those names of who you talked to when you come back. If you've hired one of them by then, great. If not, I want you talking to at least 3. Don't wait till the last minute because they're in court and they have things to do. So start calling today, talk to those attorneys, bring me back who they are, how much they charge, let me know about where you're working, bring a pay stub when you come back. The more information you bring me, the better things are going to go. Does that make sense? All right, 2 weeks. Step in front of the clerk. You probably already did that too. All right, so you're Andrew Jackson.
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the indictment?
Please, Your Honor.
Mr. Jackson, in cause number 23, DCCR 0045, you're charged with a second-degree felony offense of sexual assault of a child from June 7th of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
and because you did what they charged you with.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And the agreement is for a 12-year term in prison with dismissals in your other cases. Your attorneys have talked to me about me resetting the case for a week so that the victim can be here and so that you can take care of any final business you need to. I want to make sure you understand that if you do not show up next Tuesday, then this deal and all deals are off the table. We've gone round and around with this. You will be going to trial, and it will likely be within a couple of weeks. There will be no resets. We're going to get it taken care of. Do you understand?
Yes, ma'am.
Okay. If you're arrested for anything between now and next Tuesday, you run the risk of me not accepting the plea agreement. So get done what you need to get done. Show up next Tuesday. Get it all taken care of and behind you, and everything will go as according to plan. Okay?
Yes, ma'am.
State tenders number 1.
No objections, yes, ma'am.
It's admitted. Is there any evidence that Mr. Jackson is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I am going to reset your case to next Tuesday. I do not need a pre-sentence report done, and you need to be here at 9 o'clock next Tuesday morning. Okay? All right, we'll see y'all Tuesday.
Excuse to that.
Yes, sir, thank you. I printed that, and I'm just going to put a sticky note on that. So what the agreement is, that's one way, if we can hang on that to next week. This is cause number 24, DCCR 2332, and Mr. Brandon, you tested positive for THC. We have had issues over and over again with drug patches and drug testing court, and you not having, I don't know. It doesn't matter at this point because you tested positive. You're here because we had an issue of you not having your drug patch or not being testable, one or the other. And so, yeah. So at this point, and the thing is, you were on 100, you already didn't show up for court once, and your bond was raised to $100,000, and it looks like that was never reduced. You made a $100,000 bond?
Yes, ma'am.
You made a $100,000 bond, and you're out smoking marijuana or doing something that's going to make you test positive for THC. That makes no sense. At this time, I'm going to find that you violated your bond condition order by testing positive and by also not having your drug patch testable every time. I'm going to raise your bond in your case to $175,000. Obviously, a condition of that bond is that you have a drug patch on at all times. Have it tested every 2 weeks like you're supposed to if you make that bond, and then we will reset your case for an announcement. You can go back with the bailiff. All right, sir, you're DeAndre Smith?
Yes, ma'am.
And Mr. Frank, will your client waive the formal reading of the indictment?
Yes, ma'am.
I'll take that.
I need to sign it. And Your Honor, my office is going to send the audit report to the court.
Thank you. Mr. Smith, in cause number 24, DCCR 2404, you're charged with a second-degree felony offense of collision involving death from July 18th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them, but the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Frank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
There's no evidence at all.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there.
Yes.
Okay, we'll see y'all back at sentencing. Thank you.
Thank you very much, ma'am.
All right, sir, you're Devin Spites. All right, this time I am going to recall the bond forfeiture, and bless you. Mr. Spites is charged with theft of property, and what is the announcement? I know you're attempting to file a motion to withdraw. We obviously cannot take care of that today. You need to, is there anything, have you discussed the case with the district attorney as far as working anything out while y'all are here, or no?
No, not this morning, not yet.
Okay. Do you want time to do that, or do you just want me to?
If there is an offer, I can convey it to my client.
It'd be 5 years.
I think we'd be working that out.
Okay. So here's what I'm going to do. I'm going to reset the case, a normal reset, which is about 30 days. Anything that you want to get filed between now and then, make sure you get it filed in plenty of time, and then we'll take care of that at the next court date. Obviously, you'll be required to be here, and then we'll go through if it's a motion to withdraw. Mr. Spites, if there's an issue with your being able to continue with Ms. Hawkins, you know that's coming. Y'all talk about it. If y'all work something out, great. If not, you need to understand that you will be required to try to hire another attorney, so you can go ahead and try to get started on that as well. Okay? All right, we'll see you on 30 days.
Thank you, Judge.
Thank you.
Good morning, you're Caitlin Talmore. And Ms. Talmore, this is your initial appearance in cause number 25, DCCR 0595. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that is from April 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So what happens is when you're in custody in jail, we automatically give you a court-appointed attorney. Now that you've made bond, I'm going to expect you to at least try to hire your own. So what I'll do is reset your case for about 30 days to give you some time to try to hire somebody. If you do get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to go visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of those you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail. Do you understand? Yes. All right, step in front of the clerk. She'll give you your reset notice. Good morning. You're Janisha Leonard? Yes, ma'am. Let's see, and Ms. Leonard, you have 2 motions to revoke your probation, and then you have a new case in cause number 25 DCCR 0297, and I set bonds, and you've made bonds on all of those. And have you had an opportunity to hire a lawyer? Okay, so you need to get someone hired. The fact that I set those bonds at what I did, even when the state asked me not to, you've got some serious stuff going on. You need to try to get someone hired if you can before that next court date. So I'm going to reset your case for 30 days. You need to try to get someone hired. If you do, bring the reset notice to them. They'll tell you what to do. Go ahead. Well, you need to try to get a job first. And you need to apply to at least 5 jobs a week, and you need to bring me proof of that. Okay? If you do get a job, bring me some proof that you have a job. In the meantime, I will also want you talking to lawyers. Bring me back the names of the lawyers you've talked to, at least 3, so I know you're trying. Bring me the information about that you're trying to get a job, and then we'll discuss all of your options. Okay? If you don't do that, then your bonds will be raised, especially on those motion to revoke probations. You'll be right back in jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice, because I don't usually do all of this. All right, you're Anthony Salvato. Mr. Salvato, you're here on a motion to revoke your probation, and I set a bond in your case. Let's see, I feel like we had received some letters. You were participating in the veterans and all of that.
Yes, ma'am.
You're still doing all of that?
Yes, ma'am.
Good morning.
Good morning.
What is your name for the record?
Catherine Branch.
Okay, and who are you with, Ms. Branch?
Probation.
Okay, thanks. Sorry. And so has he been following through and everything with regard to probation? Okay. Have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right. Are you working?
No, ma'am. I've been trying to do the program that we have I have had a couple of interviews, which I have not been successful because of my record, my health diagnosis. It's been very difficult. I have attended some veteran work job fairs, and that was unsuccessful as well.
Okay.
So, but I have been and I am seeing a employment counselor once a week.
Okay. What I'm going to do this morning, Mr. Salvato, and I'm looking back, I have some documentation from the Veterans Association and things like that with regard to when I set your bond. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. All right? Step in front of the clerk. She'll give you that paperwork. Thanks, Ms. Branch. Sorry, I didn't recognize you. Good morning. You're Daryl Spencer. Mr. Spencer, did you get someone hired? Did you already hire him?
I was gonna pay him today.
Okay.
I had money on me right now.
Okay. Did you talk to him about where you were going to meet, or?
I told him about my case and stuff like that. He told me he could make a payment plan with me because I talked to Marcia Bowman and she told me she couldn't.
Okay. So you have the money to hire him?
Yes, ma'am.
All right. I'm going to reset your case 2 weeks.
Yes, ma'am.
You need to get him hired before that next court date.
Yes, ma'am.
Right. Step in front of the clerk. She'll give you a reset notice. I have filed and agreed. That's in the other one.
That's the one I've got.
Okay.
I believe she is ready, Your Honor.
Okay. And they were talking about a possible resolution last week, but they didn't do that. So if you'll get with them, her. All right. Then I'm going to number, is Dustin Knight here? Did you tell him not to be here?
They didn't.
Okay.
They're not gonna.
And then on Jesse Salinas.
We spoke, last week, Judge. Me and Mr. Gertz.
Uh-huh.
We're close, agreement, if the court will allow us one recess, we'll be ready at that time.
Okay.
I've got all my witnesses, playing witnesses in Florida, I've got witnesses out of state.
Okay.
But I've talked to him about it and he's all right.
I mean, they'll still be out of state next time, right?
I'm gonna say,
Okay.
but we didn't, I don't.
I mean, I didn't mean to be
I'll-
smarty about that. I'm just
No,
saying.
no, I understand, but that's, we were in agreement on that. I don't believe he was ready as well.
I gave you a trial.
But a quick reset of thoughts.
Okay. You did, Kelly Lee.
Yeah, we're doing the bond ones today since we're off next month.
Oh, this is for trial in
2 weeks.
2 weeks.
2 weeks. I meant to call you, but your email was.
Okay, I'm going to grant the motion for continuance, this time in Mr. Salinas' case, but there will not be another.
Yes.
Thank you. And if you'll just relay that to Mr. Gertz
I
as
will,
well.
yes, ma'am.
Good morning, sir. You're John Van Wright. And this is 24 DCCR 2485, and then there's the motion to revoke probation in 15 23582.
Judge, I know Mr. Mitchell was trying to get with Mr. Smith. He didn't realize he was out last week. He was having trouble watching the video they need to watch. I know enough about this case to know they need to watch that video.
Okay.
So I'm asking for a reset so they can do that.
Okay. I will do just a normal reset. Obviously, if there's any issues, if you can get with Mr. Nichols or Ms. Malfino, I'm sure either of them will help you work that issue out, and we'll get an
I think it just
announcement.
wouldn't play for him, so he was going to come to our office and do it.
Okay.
If he needs me to do it for him, I would gladly will do it.
Okay.
So I'm setting trial this morning in the 128th with Mr. Gertz. We're both under trial protection.
Okay.
As soon as that ends, I'll give Mr. Nichols a call. And we'll
Perfect. And Mr. Smith might be back by then as well, and so, but if not, just get with Mr. Nichols or Ms. Malfino, they'll help
Will
you
do,
out.
Judge.
Okay.
Thank you, Your Honor. I appreciate it.
Stay in touch with Mr. Mitchell. He'll let you know when you need to be back. Thank you. Okay. Y'all are gonna have to give me just a minute so I can.
Yeah, I'm gonna need to write that up.
Because also we'll need the certification. You want me to hold it for a second?
Yes, please.
Can y'all just have a seat real quick, just so that we can get all that paperwork pulled up? You're good. Good morning, sir. You're Ronnie Oliphant, and this is 25 DCCR 0379, and what is your announcement?
I'm still reviewing the discovery with Mr. Oliphant.
Okay, any issues, Mr. Coleman?
No, Your Honor, and we're not opposed to a reset.
All right, so we'll do another about 30-day reset. Mr. Oliphant, make sure you stay in touch with Mr. Comerford so you can go over all of that information and discovery that he's received, and then we'll try to get an announcement at the next court date. All right, you're free to go. Thank you. And then Simon Gobert, you're here for Mr. Flory on that one, Mr. Comerford. All right, sir, you're Simon Gobert, and this is cause number 24 DCCR 0512. Mr. Gobert's charged with attempt to commit sexual performance by a child. What is the announcement?
I'm still reviewing the discovery with Mr. Gottlieb.
Okay. This case is old.
It was re-indicted, Your Honor. Have you got everything you need, or?
Yes, I think I'm missing something, but we can talk about it.
All right, let me know what it is.
Okay. It looks like you substituted in, y'all substituted it just in mid-June.
Yes.
So I'll do one more reset. Get with Mr. Hoffpower. He'll work with you on whatever you don't have, and I'd like to try, even though you're fairly new on it, I'd like to get an announcement at that next court date.
Will do.
Make sure you stay in touch with your attorneys so that you can visit with them about everything, and we'll know which direction your case is going to take at that next court date. Okay? Thank you. All right, ma'am, you're Ashley Riggins. And Ms. Riggins was previously in court, entered a plea of guilty to unauthorized use of a vehicle in cause number 25 DCCR 0092. The agreement was for 15 months in the state jail prison. We didn't order a pre-sentence report. Is there any reason not to go forward with sentencing today?
No, Your Honor.
And Ms. Riggins, have you gotten into any trouble since your last court date? Okay. Then at this time, I am going to find that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody on this case that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Coffin. All right, good luck to you, ma'am. You can go back with the bailiff. Thank you, Ms. Coffin.
May I be excused, Your Honor?
Yes, ma'am, thank you. Mr. Nichols, this is Raphael Glover.
Yes, sir.
Sir, are you Raphael Glover? And this is 24 DCCR 0232. Mr. Glover's case is set for trial to begin with jury selection on Monday the 8th. And what is the announcement?
Your Honor, the state has tendered an offer of 5 years in this case. They've also indicated through a notice of enhancement that the punishment range will be a second degree, 2 to 20, because of a federal conviction that Mr. Glover has. He's refusing the 5 years, and we're asking you to continue. Is that correct?
So I want to make sure you understand. Are you ready?
Yes, Your Honor, state's ready.
And so, Mr. Glover, I will number your case for trial on that date. It's one of the older ones, so you need to be prepared. Talk to Mr. Kimler for trial. I also want to make sure you understand that after today, I will not accept that plea agreement. And so if you change your mind after today, you can enter a plea open to me or to some other agreement, but it's not going to be to that agreement for 5. Do you understand? And you want to go forward with your trial in 2 weeks. All right, stay in touch with Mr. Kimler, and we'll see you back on Monday the 8th. All right, sir, you're Johnny Polanco, Sr.?
Yes, ma'am.
And this is 24 DCCR 2168. Mr. Polanco's case is set for trial to begin with jury selection on Monday, September 8th. And what is the announcement?
I'm ready, Your Honor. This is the one the court will recall. And
It is.
He's not here yet.
I was mistaken, Mr. Sheriff or Mr. Smith. I apologize. That the other case that he was arrested on was referred to the federal authorities. There's still been no action on that.
All right, so we'll go forward with this one.
We're ready, Your Honor.
All right, the case will be numbered for trial. Mr. Polanco, stay in touch with Mr. And has there been any change with regard to negotiations or
Nothing
anything
more,
like that?
Your Honor.
All right, so your case will get numbered for trial for the 8th. Stay in touch with Mr. Kimmler. He'll know that trial order tomorrow after the docket and let you know when you need to be back. Okay? And Ms. Hawkins?
Yes, ma'am.
Good morning, Ms. Hawkins.
Mr. Spice has not arrived yet. I spoke to him last week, not this morning.
If you'll call the name Devin Spites, please. Go ahead.
The court informed me that the bondsman made contact, said that he's got a wobbly tire.
That's, yeah. You have a picture? He did let us know that the bondsman know that. It does say that he's on his way though, and so what I'll typically do is go ahead and announce the bond forfeiture. If he gets here, I'll just recall it. So if you'll just.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at $100,000.